And video, so I know that you are hearing. Okay, thank you. This the case that we believe I saw recently. There was a eval set up and they were unable to reach him to participate in that evaluation.
That's my understanding, Your Honor. I saw that as well. I think the last time we were in court, counsel indicated that the meeting had been set up to do the evaluation and the date was discussed. And it looks like Mr. Richard did not appear for that.
And for the record, Sean Parent for Mr. Richard. Yes, unfortunately, that appears to be the case. I'm not sure why Mr. Richard didn't appear at the evaluation.
So Mr. Richard, we've been waiting for you to talk to one of the doctors, and we've been setting this case over for that to happen. When you were here on April 8th, we discussed that you were scheduled for that appointment on April 24th. So I know that you were aware that they had you calendared. Mr. Richard, why didn't you show up for that appointment?
Well, that was an assumption. I wasn't aware of anything.
Well, you were at the hearing when we talked about it, so.
I don't recall.
You participated on Zoom on April 8th, and we discussed that your evaluation was calendared for the 24th of April.
Was there anything signed for confirmation?
Your attorney has been working to get that set up. So.
Well, I haven't talked to anybody.
Mr. Parent, have you been in contact with Mr. Richard?
Looks like my office, we tried to reach him to make sure that he appeared at the evaluation, but we were unsuccessful in reaching him.
Do you have proof of that?
Yes, I have my colleague's notes that we tried to get a hold of you.
And what was the number?
So, Mr. Richard, we have the phone number that ends in 1752.
I'm talking about the number you supposedly contacted the defendant on.
Yeah, you're the defendant, and it's the phone number that ends in 1752.
That's an assumption and presumption.
Buckle up, guys. Today we're going to witness a courtroom exchange that quickly turns tense. The judge raises concerns about a missed evaluation appointment, something that appears simple on the surface, but immediately sparks confusion and resistance. Mr. Richard claims he was never properly informed, while the court insists the date was discussed earlier. What begins as a routine clarification slowly evolves into a standoff over responsibility and awareness.
Violation.
Under what law are you saying that I could? What charges? What are the charges?
We've gone over that. You have been told that you are charged with driving while license suspended and driving without an ignition interlock device. So I understand you disagree, but at this point we need to.
I don't disagree with none of the facts. I said, what was the date?
The date of the driving? Is that what you're asking?
Well, I don't drive, so I'm trying to figure out the date you have on file. Okay, and have I been charged with anything?
Yes.
And what is it? What are the charges?
As the court just read aloud, driving while license suspended and driving without a functioning ignition interlock.
And is there a witness that you can bring to attain to that?
Those are the criminal charges. You also were cited for not having insurance.
Yeah, but do you have a witness?
Yes, the city has witnesses. We have the officer that will be testifying.
The officer. Okay, well, can you read the police ticket on the record?
We're not having a trial today. We're trying to figure out whether or not you are competent and able to proceed in this matter, and that requires that you speak to a doctor. But that is what we're trying to accomplish. And Mr. Richard, if you refuse.
Can you explain to me? I don't understand. So can you explain to me how?
We've explained this to you previously. So what I'm going to ask you is whether or not you are going to comply with meeting the doctor out of jail, or does the court need to set bail and have you booked into custody so they can talk to you there? That's not what I'm wanting to do. I would like you to cooperate and have this case proceed with you out of custody.
Well, I need some type of contract to obtain.
As the hearing continues, the situation becomes increasingly confrontational. From an outside perspective, Mr. Richard repeatedly challenges the legitimacy of the charges and demands proof, witnesses, and documentation. Meanwhile, the court and attorneys attempt to steer the conversation back to the real issue, completing the required evaluation. Instead of moving forward, the discussion circles around the same points, creating visible frustration in the courtroom.
To whatever you're asking, because I have questions and you're not.
Your Honor, at this point, I think given the track record of Mr. Richard and his unwillingness to comply, the city is going to be asking that the court set bail and remand him on that bail to have the evaluation done in custody.
Mr. Richard, can you assure the court that you will come to an out of custody evaluation?
I will agree to anything if you guys can tell me the nature and cause of this action. My Sixth Amendment right. I need to know these things before we can move further. Are you refusing to tell me?
I didn't quite hear your question. What are you asking?
I need to know the nature and cause of this action. I need to know that before we can move forward.
Yeah, I believe that the court has told you that you're being charged with driving a license suspended in the 3rd degree and operating a motor vehicle without an ignition interlock device.
Okay, well, I have a question for the judge.
What's that,
Hello?
Mr. Richard?
Hello?
Mr. Richard?
Hello? Or can you hear me?
Yes, I can hear you. You should sit down and then instead of having me facing you at the clouds, you should participate in this hearing. Thank you. So every time we have a hearing, you ask these same questions and we've explained to you that you're facing criminal charges and that we need to have the doctor speak to you. And so right now, your option is whether or not, as your attorney said, you can agree to meet with the doctors and stay out of jail to do that, or the court will have to remand you into custody so that they can
So
talk to you
basically,
while
you're
you're
telling
in
me you're
jail.
refusing to answer me. You're refusing to answer any questions? That's what you're saying? Because I just have questions.
We've answered your questions. We're going to proceed at this.
At this stage, the tension escalates further as the judge gives Mr. Richard a clear choice: cooperate with the evaluation outside of custody or risk being taken into custody to complete it. Observers can see the court trying to keep the process moving, but Mr. Richard shifts the focus toward constitutional arguments and procedural questions. The back and forth grows sharper, and the possibility of bail being set begins to loom.
This point, I'm going to.
I didn't even ask the question. So how did you answer it? That's what I'm saying. Are you refusing to answer the questions?
What do you want to know besides what you're charged with? What was your other questions?
My other question was, did you or did you not take an oath to uphold the Constitution? Can I just get a yes or no?
That would be a yes.
So you're enforcing statutes right now, and so you're totally going against your oath. So I'm trying to figure out what authority do you have to tell me to do anything as a public servant?
Mr. Richard, I am authorized by the revised Code of Washington to sit in this court. I'm duly appointed to be a municipal court judge. I've taken my oath. You're charged with a violation of the RCW and the Lake Forest Park Municipal Code.
Why are you enforcing statutes if you took an oath?
I know you don't think that it applies to you, but it does. So
I didn't say it didn't apply to me.
I'm going to set bail in this matter at $10,000.
You're making assumptions, ma'am. You're making assumptions, ma'am. I never said it didn't apply to me. But we both know here that the Constitution is not for me. It is for the public servants. So I don't know why you're making assumptions and presumptions. All I had was questions. And you're just going in as
I'm
a
going
big
to
thing
set
now.
bail at $10,000 and we're going to end this hearing, Mr. Richard. You can report to jail. You can come in, but we are trying to do this without you having to be in custody, but you are refusing to cooperate.
I didn't refuse anything. I was never put on notice. So I didn't refuse anything.
I know you were put on notice at our last hearing, so that's on the record. So I know that to be false, Mr. Richard. So that is
everything that I asked you, am I wrong? Is that what you're saying?
Yes, you're wrong.
The exchange finally reaches its breaking point. Mr. Richard questions the judge's authority and oath, while the judge responds by affirming her legal authority and responsibility to enforce the law. From an observer standpoint, the courtroom dynamic has completely shifted from clarification to confrontation, with cooperation no longer happening. The judge sets bail at $10,000 and ends the hearing, bringing the tense exchange to a decisive close. Like the video, subscribe to the channel, and we'll see you in the next video.